Hi friends, welcome to EPG Pathshala. I am Sumiti Ahuja and I am working as an assistant professor with Amity Law School, Noida, Amity University, Uttar Pradesh. The module which I will be dealing with in this presentation is criminal misappropriation and criminal breach of trust, which are offences against property under the Indian Penal Code. I will be dealing it as a part of the paper Fundamentals of Crime, Criminal Law and Criminal Justice. To start with, first I will be highlighting the learning outcomes. After completing this module, the reader will be able to, or the takeaways of the reader will be, firstly, analyze and discuss the statutory framework of the offences pertaining to misappropriation. Secondly, the reader will be able to differentiate between the occurrence of dishonesty under the cases of theft and misappropriation. Thirdly, the reader will be able to understand the difference between offences of criminal misappropriation and criminal breach of trust. And lastly, the reader will be able to assess the importance of landmark case laws and usage of illustrations in understanding the concepts and the context in which these concepts are to be interpreted in the statutory provisions. Briefly giving the synopsis of the contents of this module which I will be dealing with in my presentation, I will be starting with the brief introduction of the offences of criminal misappropriation and criminal breach of trust, followed by the treatment which has been given to the offence of criminal misappropriation under the IPC. Moving on to the aggravated form of criminal misappropriation under the IPC. Then it will be followed by offence of criminal breach of trust and the aggravated forms of criminal breach of trust under the Indian Penal Code, then a brief summary of the entire presentation. We all know this, that there is a commonality or a common factor between both the offences of criminal misappropriation and criminal breach of trust, which is a dishonest misappropriation of the property or conversion of the property to one's own use. The term dishonestly is an essential ingredient of theft as well, but what makes these offences, or what is the differentiating factor between that offence and these offences, is that these offences are different from that of theft due to the reason of the time when the dishonesty actually begins. Because at the time of the offence of theft, dishonesty has to be there at the time of moving of that particular property from the possession. One other important difference which I can highlight here between theft and criminal misappropriation and criminal breach of trust is the manner in which the offender initially comes across the movable property. Now, it is the factum of entrustment which sets apart the offences of criminal misappropriation and criminal breach of trust. Now, I will move on to the offence of criminal misappropriation as it has been dealt with under the Indian Penal Code. To start with, or to define it, criminal misappropriation takes place when the possession has been innocently come by, but whereby a subsequent change of intention or from the knowledge of any new fact intervening with which the party was not previously acquainted with, the retaining becomes wrongful and fraudulent. So, section 403 states that whoever dishonestly misappropriates or converts to his own use any movable property, he shall be punished with imprisonment for a term maximum period of 2 years or with fine, or can be both. The actus reus of the offence here is misappropriation or conversion to one's own use. Any property which is belonging to someone else, and the other essential of crime, that is mens rea, in this case is the dishonest intention or to act dishonestly. Now, if I briefly move on to the essentials of criminal misappropriation as have been dealt with under section 403 or stated under 403, first is there has to be a dishonest misappropriation or conversion to one's own use, either permanently or for a time being. It has to be of a movable property which is already without wrong in possession of the offender. So, to start with, the first essential, it is dishonest misappropriation or conversion to one's own use. So, firstly I will be elaborating the term misappropriation. The term misappropriation as such has not been defined anywhere under the Indian Penal Code, but the verb to appropriate in this connection means setting apart for or assigning to a particular person or use, and to misappropriate no doubt therefore means to set apart for or assigned to the wrong person or a wrong use. And this act must be done in a with a dishonest intention. So now section 24 of the IPC has defined the term dishonestly, and it uses the term, it says that whoever does anything with the intention of causing wrongful gain to one person or wrongful loss to another person is said to have acted dishonestly. Now the immediately previous section, that is section 23, highlights or elaborates what is wrongful gain and what is wrongful loss. And if I talk about wrongful loss as given under section 23 IPC, it is the loss by unlawful means of property to which the person losing it is legally entitled. Now dishonest misappropriation under section 403 of the IPC as understood, it means that the offender with a dishonest intention appropriates wrongly the property which belongs to someone else. Now coming to the second part of this essential, that is conversion to one's own use. This connotes the use or dealing with the property in derogation of the rights of the owner. In other words, if I put up, it means dealing with the property of another in a way as if it's his own property. Say for example, if I quote an example here, X, a student, he finds a premium watch lying on the floor of his college washroom. He picks it up and he puts it in his pocket. It's not an offense. Now, instead of submitting the watch in the college's lost and found room or actually venturing out to find the true owner, he goes and pawns the watch as he was in urgent need of money. Now here we can say that he has committed an offense under this section, because by pawning the watch, the finder is dealing with it as if the watch was his own property. Now he thereby converted that property belonging to someone else to his own use and therefore has committed an offense under section 403 of the Indian Penal Code. Now if I further, while dealing with this essential, I point out this fact that what is the relation, if any, between misappropriation and conversion to one's own use. There is a question, or you can say there is this debatable point, whether the phrase to his own use as used under section 403 of the Indian Penal Code has to be read merely with the act of conversion, or it can be read with both, that is acts of conversion as well as misappropriation. Now the answer to it is that there are two separate acts. One is misappropriation. It need not be necessary that the property of someone else is used by the offender, but by keeping it and not returning it, he causes wrongful loss to the owner and therefore he will be liable. And the other act is conversion to one's own use. Now in this case, the person actually uses the property which is belonging to someone else and treats it as if it is his own property, and thereby he also causes wrongful gain to himself as against the owner. This means to his own use is only applicable for conversion or only qualifies the act of conversion. Now if I give an example here for misappropriation, now A, who was the servant of B, he was entrusted with B's money for the purchase of grain at J. Now he left for J with the money and he went off to H rather without giving any information to B of his departure. Subsequently, he gave false account of it. Now he was arrested at H place and the entire money was found in his possession. Now he further went on to argue that he cannot be liable for criminal misappropriation as it cannot be proved that he converted money to his own use. Now, for conversion to one's own use, if I give an example here, say A being on friendly terms with Z, he goes into Z's library and in his absence he takes away a book without Z's express consent. Now here, if A was under the impression that he had Z's implied consent to take the book for the purpose of reading it, he has not committed theft. But A afterwards sell the book for his own benefit. Now here he can be held liable for the offence of criminal misappropriation. Now moving on to the second essential of the offence of criminal misappropriation, which is that he misappropriates or converts to his own use either permanently or for a time being. So now explanation 1 to section 403 states that a dishonest misappropriation for a time only is a misappropriation within the meaning of this section. What does it signify exactly? The words time only indicate that the misappropriation can even be of a temporary nature. The person may intend to restore the property to whom it belongs maybe sometime later, Say, for example, A finds a government promissory note which belongs to Z bearing a blank endorsement. Now A, knowing that the note belongs to Z, pledges it with a banker, intending at a future time to restore it back to Z. Still he will be held liable because, as I mentioned earlier, time duration for commission of this offence does not matter. Now moving on to the third essential of this offence, which is movable property, or the property or the subject matter of this section has to be movable property. Movable property finds place under section 22 of the Indian Penal Code as it includes corporeal property of every description except land and things attached to the earth, or anything which is permanently fastened to something which is attached to the earth. That is something which is capable of being subject to ownership. So things which are fere naturae, they do not qualify as movable property. Now moving on to the next essential, which is already without wrong in possession of the offender. So now here the offender is already in possession of the property. He is lawfully in possession of it, say maybe because he has found it or he is a joint owner of it. Even if strictly not lawful, it is not punishable as an offence, say because he has acquired it under some mistaken notion of right in himself, or we can also say that he was having consent which was given by another. Now an example can be quoted here that A takes property belonging to Z out of Z's possession in good faith, believing at the time when he takes it that the property belongs to himself. So he does that in good faith. There is a rule in case of finder of property. It is a common law principle that a finder holds good title as against the whole world except for the true owner of that property. This rule was stated in the case of Armory versus Delamery. In this particular case, plaintiff, who was a chimney sweeper's boy, he found a jewel and took it to a goldsmith's shop to find out what it was. An apprentice from the shop, he took out the stones from the jewel and refused to return the stones to the boy. Now, it was observed in this case that the finder of a jewel, though he does not by such finding acquires any absolute property or ownership, yet his title is strong enough against the entire world except for the rightful owner of it. Now, explanation 2 to section 403 of the IPC, it provides for a rule in case of specifically for finder of property, also describing under what circumstances a finder of lost property becomes an offender by dealing with it as if it were his own. The opening part of explanation 2 reads as, a person who finds property not in the possession of any other person and such property for the purpose of protecting it for or of restoring it to the owner does not take or misappropriate it dishonestly. He is not guilty of an offence. Now, according to the subsequent part or the second part of explanation 2, a person will be guilty of criminal misappropriation if, firstly, he appropriates to his own use any movable property, when he knows the owner, or he has means of discovering the owner, or before he has used his reasonable means, he has exhausted his means to discover the rightful owner and give notice to the owner, and rather he has kept property for a reasonable time to enable the owner to claim it. Now, what are the reasonable means or reasonable time? It differs from case to case and is a question of fact. Moving on to the explanation 2, the remaining part of the explanation 2, it moves on to provide that it is not necessary that the finder knows the owner of the property. Still, it is sufficient if at the time of appropriating the property, either he does not believe it to be his own property, in such case his liability will arise, or he in good faith believes that the real owner cannot be found. Now, in such case he won't be held liable. No criminal misappropriation of things which have been abundant can take place. Now, whether a lost personal property was abundant is essentially a question of fact now, which obviously will definitely be inferred from the circumstances. Say for example, factors like where the property was found, the nature of the property, value of the property, they act as relevant considerations when we venture to determine whether the owner had intended to leave the property. Now, more is the value of the found property, lesser is the chance that the same has been abandoned by the owner. Now, further, I will be moving on to the difference between theft as an offence against property and criminal misappropriation. Differences lie in, firstly, initial taking of that property, secondly, invasion of possession, thirdly, the moving of property, fourthly would be the consent of the owner, next, developing dishonest intention, followed by the offence which is committed by the owner. Now, despite the differences between them, there are certain similarities also. Firstly, the first similarity between theft and criminal misappropriation is that in both the offences, the subject matter is movable property. Second is that dishonest intention is the mens rea for both the offences. Thirdly, deprivation of property, whether permanent or temporary, the time factor is immaterial in both the offences. Now, I will move on to the aggravated form of criminal misappropriation under the Indian Penal Code. Committing criminal misappropriation against property possessed by deceased person at the time of his death is considered to be an aggravated form of this offence and punished more strictly if the offender at time of such person's death was employed as his clerk or servant, because obviously of that fiduciary relationship. Now, the governing section for this is section 404 of the Indian Penal Code, and the punishment here is maximum imprisonment of 3 years, and in case the act is committed by the clerk or servant of that person, the deceased, maximum imprisonment can go on to 7 years. Here the prosecution has to prove that firstly the property was in possession of or it belonged to the deceased person at the time of his death, and secondly it has since been misappropriated or converted to his own use by a person who knew or who had the reason to know that it belonged to the deceased. Now, I will move on to the second part of this presentation, wherein I have dealt with the offence of criminal breach of trust under the Indian Penal Code 1860. I will briefly give the statutory framework. To start with, section 405, wherein the offence of criminal breach of trust has been defined. Then further the punishment which has been stated under section 406. Then further moving on to the aggravated versions which find their place under sections 407 and 409 of the Indian Penal Code. Now, criminal breach of trust is an offence under section 403. It is certainly a minor offence in relation to the offence under section 406 of IPC. Reason being the trust factor plus the punishment. Now, the essence of offence in this case lies in dishonest intention, and therefore this is what makes it different from breach of trust as given under or as it finds mention under the civil law. Now, I will move on to the essentials which are required or which are necessary to be proved in order to determine liability under criminal breach of trust. Firstly, entrustment of property. It can be either movable or immovable, unlike in case of criminal misappropriation, or entrustment of dominion over property by one person to another. Then dishonest misappropriation or conversion to his use by the person who received the property in trust. Then dishonest usage or disposal of property in violation of firstly any direction of law prescribing the mode in which such trust is to be discharged, or secondly any legal contract made touching the discharge of such trust. If I briefly elaborate the essentials of criminal breach of trust, firstly entrustment of property or entrustment of dominion over property. Entrustment is understood as confiding of the care or disposal of something to someone. It implies voluntarily handing over of custody or management of the property to someone for some purpose. Now, the law contemplates that the offender should receive the property and hold it on behalf of another, so that he should be the trustee of the property. Now, in a Supreme Court judgment, it has been held that the term entrusted found in section 405 IPC governs not only the words with the property immediately following it, but also the words or with dominion over the property. Now, dominion, this term dominion refers to having a charge over property or control over the property. So, in order to show entrustment of dominion under this section, it is not enough that the person has dominion over property. In fact, it has to be proved by the prosecution that dominion was the result of entrustment. Now, dishonest misappropriation, if I talk about Stridhan property, it also amounts to criminal breach of trust, which has been led in which has been held in a Supreme Court judgment. Now, moving on to the next essential of criminal breach of trust, it is dishonest misappropriation or conversion to one's own use. Now, as highlighted in criminal misappropriation also, here also the actus reus of this offence as well consists of either of the 4 positive acts: misappropriation, conversion, user or disposal of property. So now, if due to occurrence of any unfortunate or any intervening situation, the person to whom the property has been entrusted is disabled from carrying out the purpose of entrustment, the same will not attract the application of this section unless misappropriation, conversion to own use or disposal of property is established. Now, similar to criminal misappropriation, even a temporary misappropriation in this case as well is sufficient for conviction under criminal breach of trust. Now, moving on further to the explanations to section 405, explanation 1 and 2, they provide that an employer of an establishment who deducts employee's contribution from the wages payable to employee for credit to provident fund or other funds shall be deemed to be entrusted with the amount of that contribution which is being deducted by him, and default in payment will amount to dishonest use of the contribution and so will constitute an offence under this section. Next is dishonest user or disposal of property. Now, criminal breach of trust can also be result of dishonest user or disposal of property in violation of any direction of law prescribing the mode in which such trust is to be discharged, or any legal contract which is made touching the discharge of such trust. Now, in my presentation, I will move on to the next part, that is the difference between theft and criminal breach of trust. The various heads under which we can differentiate between theft and criminal breach of trust is firstly acquiring of property, secondly is the nature of property, thirdly completion of the offence, and now coming to the difference between criminal misappropriation and criminal breach of trust. In case of criminal misappropriation, the property comes into possession of the offender by some casualty or otherwise, whereas in criminal breach of trust, the offender is lawfully entrusted with the property and he dishonestly misappropriates the same. In criminal misappropriation, there is no contractual relationship, whereas in criminal breach of trust, there is one. Now, I will move on to the last part of this presentation, that is aggravated forms of criminal breach of trust, which are stated under sections 407 to 409 of the IPC. To start with section 407 of the IPC, it deals with criminal breach of trust by carrier, wharfinger or warehouse keeper, wherein the maximum punishment extends to 7 years and fine. Now, the categories of persons mentioned under this section are those who receive property or goods under a contract and they are supposed to safely either carry the goods or to save them in a safe custody. Now, courier is a person who undertakes to transport the goods for hire. Wharfinger is the owner or officer in charge of a wharf who takes care of goods for shipment or delivery, and warehouse keeper is keeper of a warehouse, which is a place which is licensed for storage of goods. Now, moving on further to section 408, which again is another aggravated form of criminal breach of trust. It deals with criminal breach of trust when committed by clerk or servant or anyone employed as a clerk or servant and entrusted in such capacity with property or with any dominion over property. Now, in this case, the maximum punishment again extends to 7 years and fine. Now, clerk or servant is entrusted with master's property to either sell or dispose it off in a particular way. It may also apply to cases where clerk or servant is appointed to collect money and give the same to the master. Now, under English law, it is termed as embezzlement, defined under Theft Act of 1968. Now, moving on to the next aggravated form given under section 409 of the IPC, it deals with criminal breach of trust by public servant or by anyone in the way of his business as a banker, merchant, factor, broker, attorney or agent. Punishment in this case is stricter. It can be imprisonment for life or imprisonment of either description for a term which may extend to 10 years and fine. Now, persons in a fiduciary relationship, they have a greater responsibility on themselves of keeping honesty as they have more control over the property entrusted to them due to the special nature of their relationships. Now, moving on to the last part of my presentation, wherein I will be summarizing the points which I have taken up or explained under in this presentation. To start with, in both the offences of criminal misappropriation and breach of trust, initial possession of the property is lawful, but subsequently the offender develops dishonest intention and he diverts the property to his own use. Criminal misappropriation comprises of dishonest misappropriation or conversion to one's own use the movable property belonging to someone else. In case of offence of misappropriation, the guilt of offender is determined by the state of his mind at the time when he appropriates the property to his own use, as the initial possession is innocent. Now, in case of finder of goods, it is well known that a finder has a better title than the whole world, except for the rightful or the true owner of the property. Section 404 IPC provides for aggravated form of criminal misappropriation and is considered as special provision for protection of vulnerable property. Criminal breach of trust differs from breach of trust under civil law in terms that the former act is driven by dishonest intention. Now, in criminal breach of trust, the offender dishonestly misappropriates, converts, uses or disposes of the property or the dominion of property he is entrusted with. The subject matter of this offence can be any property, be it movable or immovable. Lastly, section 407 to 409 of the IPC represent aggravated forms of this offence with comparatively severe punishment. Friends, thank you for going through this presentation. I hope you will be able to analyze, evaluate the essentials to determine liability for both these provisions. Thank you.